Hi, good morning. Welcome again to the Jahangir channel where we take up the syllabus for executive old and new. Currently, we are doing the new syllabus portion. We have completed half of the chapter of copyrights, and today we will be covering the other half of Copyrights Act from the module. So before I start, I need a confirmation from all of you all whether I'm audible and visible in the chat box, and we will quickly continue. Okay, so without further ado, when I start, I will start and finish the entire topic. So all I need is you keep your modules open and ready with a pencil, and just be with me for 1 hour approximately, and your chapter will be completed. Okay, so now before I start, I need you to confirm whether I'm audible and visible in the chat box. Okay, so we can quickly start. Okay, thank you so much, Sona, for confirming. Okay, if others can also confirm, it'd be great. Good morning to everyone. Just waiting for you all to confirm. Okay, it just takes 2 minutes or 2 seconds to just put in yes, I'm audible and visible. Great. Okay, nice. So let's begin with the particular topic. So yesterday we had completed the entire chapter till this part, copyright societies. Okay, we finished till copyright societies, and now we will continue from there. Okay, so let's begin. Good morning, Yeshu. Great to have you all again. Okay, so let's begin with and continue with the chapter. So we had seen what are copyright societies. Copyright societies are where the creators, authors, performers, create a society. They give their rights to the society, and then the society will now license it to the people and the companies, whoever need their songs, performances, etc. Collect the royalties and give it back to the creators. Now we will be seeing something called as broadcasting rights. Now what are exactly broadcasting rights? Now if you see the very popular cricket or sports broadcasting, if I talk about, is the Indian Premier League. Now when you see the IPL, is the IPL relayed on every single sports channel? Yes or no? Obviously not. What happens is there are biddings to broadcast this particular event. So there are bids, various channels and broadcasting companies bid and try to get these rights. In for TV, the Star channel had paid 23,575 crores to get the broadcasting rights of the IPL on the TV. When we talk about the digital rights, okay, on other OTT platforms, then it was Viacom which got the digital rights for the broadcasting of the IPL. Now, similarly, if I ask you, so you've understood till now about sports broadcasting, not all these, sports events like the Olympics, or if I say the, the Pro Kabaddi, or if we see other WWF, if you know WWE, which is now, those things. So the MMA fights, they are not relayed on all the things. These certain channels have to buy these broadcasting rights, and only on and then they get these rights where they can play these live shows, recorded shows on their channel. Similarly, if I talk about OTT channels, very common among the young generation, the Gen Z. So you tell me, which is the channel that the OTT platform that you watch the most, whether it is Netflix, Amazon Prime, Voot, or Disney Hotstar, which one? So now you will say which one you select, or which you will say which is good on basis of the shows broadcasted within it. For example, Netflix will have Shark Tank USA. Maybe Amazon Prime might be having the rights for broadcasting your Shark Tank India, and so on. So on depending on which series is there, because those channels must have bought those rights for the series, accordingly it will be played. So what rights do these broadcasting channels have? So they have to first buy these rights from the creators, and then we will see what are the rights called as broadcasting reproduction rights. In your Indian Copyrights Act, Chapter 8, consisting of Section 37 to 39A, deals with the rights of broadcasting organizations and performers. So these broadcasting organizations who have these rights to broadcast a particular show, a particular event, a particular sports play, etc. So we will see what all is there. It's very simple. They will have a right to play it live, to play recordings of it, to remove any sound, all rights they have. Section 37 says every broadcasting organization shall have a special right to be known as the broadcasting reproduction right. So these broadcasting channels will have a right called as broadcasting reproduction right. And as we saw, mostly copyrights were there for 60 years. For broadcasting reproduction rights, it is there for 25 years. Mark this as very important, that once these channels, they buy these rights will be with them for 25 years. Okay, from the year, the fresh year starting from the year in which they have bought it. For example, in 2023 they have bought it. From 2024 onwards we will count the first year. From the beginning of the calendar year next following the year in which the broadcast is made. Okay, so broadcasting rights are there for 25 years. Now what rights do broadcasters have? This is very important and very logical as well. If I have bought the broadcasting rights, I have a right to rebroadcast. 100 times I will keep playing, replay, I will show the highlights, I will show, so those, if you see all those cricket matches, again there is a rebroadcast of the same thing. They can make paid public viewings. Now when you go to see Netflix, etc., they tell that you have to pay for them to watch it, to be seen. Or we have some on payment demand. Now what happens is, on payment demand OTT platforms. What does it mean? For example, if I want to watch, if I'm even if you're going in flight, in plane also it says that you can pay 30 rupees and watch this particular movie. So similarly, for each particular show or each movie can also be done, the broadcasters will decide how they want to put it. Right to recording, obviously when it is shown live, they will also have a right to record it and play it again. Right to reproduce those recordings, also it is there. Okay, even the sound of it, if you remember the IPL, if a company has a right to play the IPL, even the IPL music is very very specific. So from that, the sound recording can also be done and played again and again. Right to commercially distribute on commercial renting. This is also very interesting, that the broadcasters will have a right to further sublet or further rent out the broadcasting recordings which they have. Okay, so if they want, they can distribute their rights and sell their rights further ahead. So it could be more like a B2B transaction. So simple, we saw what are broadcasting rights. We saw what is the tenure, that is 25 years that they have the rights of those broadcasting rights are subsist for 25 years. And we saw that what are those rights? Right to take recordings, right to record, right to play it live, right to put it in public viewing, right to take any sound of it, etc. Now we are talking of performers' right. For example, if I have a show, okay, I have a singing competition and I maybe have a singing concert. In those concerts, what rights do the performers have? And how much time can the performance that they have be protected in their name? So even the tenure of the performers, can you tell me, think and tell me how much it is? We saw that mostly it was, for copyright, it was life of the author plus 60 years. And mostly it was for 60 years only. Then we saw for broadcasters it is 25 years. What is the tenure for performers' rights? How long can they protect their performance from being copied by anyone? So the answer is, it will be there for 50 years. Twice of what is there for broadcasting, just to remember. Now let's understand what is a performer's right. Similarly, a performer means any person who is a musician, who is a dancer, a magician, any person who conducts a performance, and he will be called as a performer. Section 38 provides that where any performer appears in any performance, he shall have a special right known as a performer's right. Just like broadcasting organization has broadcasting reproduction right, a performer who is a part of a performance will have a performance right. The performer's right will subsist for 50 years again. Now same concept, same points will be there. Exclusive rights. Now obviously the Copyright Act give exclusive right. Now the exclusive rights to do what? A performer will have exclusive rights to do and prevent others from doing the following. To make any sound recording or visual recording of his own performance. 1. To broadcast that performance or communicate to the public. Okay. So 2 rights that he has. First is he has a right to make a recording, whether sound or visual recording or both, and to broadcast. Let's take an example. There is a concert. The concert can be recorded. It will be completely in the control of the performer. This recording, what he will do after he records it, he will make reels, he will make YouTube shorts, he will further put it on different channels, and he will further commercially rent it. So he can reproduce any of those in any form that he wants in electronic means, and he can even store it. So first is the performer has a right to take a backup. That is always a fair use of his recording. He can issue copies to the public. He can make a CD and he can give it to the people. Communication of it to public, so he can communicate to public. Maybe he can relate YouTube live. That he can do. Then next, if you go to see selling it or commercial renting, which is the most common part. And to broadcast also. So he can give some broadcasting organization the right to broadcast. So he will have to give the right. Now what happens is some of the performances can be used in movies as well. Nowadays performers are nothing short of movie stars, superstars. So what they are saying that, listen, if there is a performer, he has given his consent, he has agreed or consented that his performance be incorporated in a cinematographic film. For example, there was a movie of, let's say, a sports hero. He wants that his his performance can be shown in the movie. We saw Dhoni, MS Dhoni, some of the shots and the sounds of the IPL were shown. We had seen a movie called in 1992 where we had won the World Cup. So that time, around that time, so that was a movie of Ranveer Singh. There were real clips from the actual World Cup which was shown. So that was a performance. If he has consented to allow that performance to be, or we have Bhag Milka Bhag, it was a movie. So if a performer is allowing his performance to be shown in a cinematographic film, then he shall not object. Then he should not create any issue, provided he gets a proper royalty. He should be entitled to royalty. Simple logic. Performance, you can use it in the movie, but give me royalty. That's what it is saying. Now, one of the most important and most repeatedly asked question is, what is the moral right of performer? And why is it important? Moral rights of performers and why it is important. So mark it as super important. Let's see. So moral right of a performer is a right even after he has assigned it to someone, he still has these rights. Means I have given my rights to someone, but still I retain some rights with me. They are called as a moral right, that these are fair rights we have to give him, even if it is being given to someone else. So moral rights are available to the authors even after the economic rights are assigned. So even after we have given our rights, assigned it to someone, we still have these rights. Now what can be those rights? That is given in section 38B. One is the right to be credited as the performer. They should mention that it's about me in the credits of the movie, or somewhere they have to give the credit to the performer. Second, if there is any modification, mutilation, change or distortion of the original performance, then I have a right to object and seek damages. So there are only two moral rights of a performer. That is, I have to be named as if I am the performer, unless it is not possible or it is impossible to show it. Okay, so I have to be credited as a performer, and second, if there is any changes, I have a right to object. So these are two moral rights of performers. That is, even after they give to someone, they have these rights with them, especially if these changes are harming or prejudicial to his reputation. If imagine there is some distortion in it, some facts are not shown properly, I am shown in bad light, so then I can object and claim damages. Copyright protection for foreign works. Now this is also a very simple concept, but now it is gaining importance because internationally we are entering into lot of treaties. Okay, and because of that, the government of India has passed the International Copyright Order 1958. Now what are these things? Okay, we have entered into various treaties, the Berne Convention, the Universal Copyright Convention. Okay, we are members to these conventions. So because we are members to these conventions, we have made this particular law, and this is there. What it is there is very simple. What it is saying that, listen, if there is a copyright, international copyright that we have to protect, we will protect only if that country is protecting our citizens in that country, reciprocal basis. So what does it mean? I will ask you a question and you will answer. If there is a foreign work, if there is some foreign work by a foreign author, will Indian government protect it in India? Answer is yes, we will protect, provided our work is protected in their country. So reciprocal basis protection will be given. So this is what it is saying, that copyright applies normally only to work in India. Okay. However, section 40 is saying that, listen, we are extending all the benefits of the provision of the Act to work for first published in any foreign country, for works published in foreign country also. The benefit, now this is the most important line, that we will not protect any foreigner if that country is not protecting Indians. So this is reciprocal basis benefit. So benefit is granted to foreign work, it shall be available on reciprocal basis, that the foreign country must grant similar protection to the works protected by Copyright Act of India. So this is an international treaty that we have entered, and this is the treaty of giving reciprocal protection to the creators. So we have also signed the Berne, we are also members of the Berne and the Universal Copyright Convention, which says that give reciprocal benefits to the people, same treatment. National treatment should be given to foreign work. Now let's see the copyright order. Now the International Copyright Order was passed pursuant to section 40 we just saw. Okay, and they have given you a few definitions. I told you there was the Berne Convention. Now what is the Berne Convention? Means Berne Convention country. That means a country which is a member of the Berne Convention is a Berne Convention country. Simple. Second, phonogram. Phonogram means what? I'll tell you what this entire order is, but just let's see a few definitions. It's a very simple order. Phonogram means sound. Just remember, we call it as sound recording. Here we are calling it phonograms. Phonograms is exclusive fixation, that is sound recording of a performance. Phonogram convention country means a country which has accepted, ratified the phonogram convention, which was done at Geneva. Simple again, one was Bern, one was Geneva. And now we are seeing Universal Copyright Convention country. Again, so it means a country which has either ratified, accepted, acceded to the Universal Copyright Convention. Simple. And now let's World Trade Organization country. So again, a country which is a member of the WTO. So the definitions are the same, that it is a country which has signed this, a country which has accepted this, a country which has ratified this convention, okay, and a country which is a member of this convention. So definition is very, very simple. But what do they say? What is this order? What are they saying? Very simple, very, very simple. So they are saying that, listen, we will extend the Indian copyright law to foreign work, to foreign cinematographic films, to foreign literary work, to foreign sound recordings, to foreign computer programs, provided similar protection is given to Indian citizens in that country. You help us, we help you. Okay, you scratch my back, I scratch your back. So it's reciprocal basis. So here they have given that foreign published works published in countries specified in the schedule. So all these conventions have a schedule. They give you who are the member countries. Work published in countries specified in the schedule. So they are member countries. So they will be treated as if the work was published in India. So let's say if we have signed USA and India are members, are convention countries. If a US citizen has published some copyright work, it will get protection in India as if he was an Indian citizen, as if the work was of India. Similar thing, this was of foreign published work. Now we will see foreign national authors. Again, now we are talking of nationals, okay. This was published where? In the scheduled country. Now we are seeing work, if it is not in a scheduled country, still protection will be given. So how? Let's see. Works first made in a country other than the scheduled country, then will they get protection? Yes or no? If I have published work in a country other than the specified country, will they get, or other than a member country, will they get protection? Yes or no? Answer is no. But they've given you a condition that will be protected as if he's an author of Indian citizen if the author was at the date of publication a national of the specified country. That is, work when it was published, maybe was published in some other country, but he is a national of member country, so he will still get protection. Understood? For example, US citizen went in Pakistan and published in Pakistan. Now Pakistan is not a member country, but he is a national at the time of the publication of a member country, so we will give him protection. Why? Because we are protecting the person, right? We are protecting the citizen of that country. So ultimately the country, Pakistan, is not getting any benefit. The citizen of USA is getting the benefit. Unpublished work. Again, unpublished work, will they get protection? Answer is yes. If it is from a specified country, will also get same protection. Corporate work. So companies doing some ads, companies ads, company taglines, company anything, okay, companies work, copyright work, companies publication, they will also be protected if they are from corporations from incorporated from specified country. It will be treated as if it was incorporated under the Indian law. Same line being replayed in different words. Even for sound recordings, binationals or corporations from specified countries are protected under the Indian law. This is nothing but the entire International Copyright Order 1999. Then again, talking of broadcasting in WTO countries, same concept, that Indian Copyright Act also applies to the broadcasters and performers from countries in the WTO. So whoever are signatories to WTO, we will also protect them. The broadcasters shall also apply to broadcasters and performers from countries of WTO. So WTO members countries are also protected in India. So WTO member countries are also protected in India. Why? Because they are member of WTO. So they are also going to protect Indians. Now copyright term limit. Now what does this say? That let's say we are talking of two countries, right? We were talking of USA and we were talking of India. So if he is, and both are, let's say, members of WTO, they are member countries or scheduled countries, whatever. If now pay attention to this, if in USA it is published, will it be protected in India? Yes or no? If a work is protected in, both are member countries, and USA citizen has published some copyright work, will it get protection in India? Yes or no? Answer is yes, because they are member country or scheduled countries. But my point is, if in India for literary work we give 60 years protection, for literary work we give 60 years protection, but in USA they give only 25 years protection. So the protection for India will last for how long? So it will last for whatever time what was there is given in US laws, right? It shall not exceed that which is enjoyed in its country of origin. So even we will also say, listen, in your country of origin you get 25 years. So here also you will get 25 years of protection, not 60 years. The term of the copyright, how long protection will be given, shall not exceed that which is enjoyed in its country of origin. I said in a country of origin, how many years you are enjoying protection? 25 years. So in India also we cannot give you more protection. Now we are talking of country of origin. What do you mean by country of origin? We are using country of origin, but country of origin means where the work was first published, right? So country of origin means the work where it was first published under any of the convention countries, Berne Convention, Universal Copyright Convention, or the WTO Convention, in whatever agreement. But work was first published in a convention countries. We are talking of country of origin. Now I say, listen, I made an online publication and it relayed directly in multiple countries. See, nowadays publication could be newspaper, so I know it is territorial. But if I make an internet publication, okay, it is available to the world. So when multiple countries are involved, if a publication is in multiple countries, if published in multiple countries, it's the one with the shortest copyright term will be treated as country of origin for the published work. In published work, whichever country is giving the least protection is the country of origin. Why? Because it is multiple countries. See, one country we never had a problem if it was published first. Let's say it was published first in USA, then in Europe, then in Africa. So we know that it was first published in USA. So that is the country of origin. But if I tell you that it has been published simultaneously everywhere, so then we'll say which is the country of origin, whichever gives you the shortest term, shortest copyright term. Because we, as it is, we don't give more protection than the term. So if the shortest term is there, so we'll say country of origin term gives you 25 years. So we will also protect you for 25 years. But the rule is different from unpublished work, ironically. So for unpublished work not covered by the international agreement, it's either the author citizenship country or the country providing longer copyright protection. See, for unpublished, we don't know who this guy is. There is a publication come and nobody is claiming benefits of it. So we give whichever is the longest copyright term. If author comes in between, then the author's country. So we are done with the international copyright order. Now we will see the copyright registration. So copyright registration, is it mandatory or not mandatory? Is it mandatory to register to get protection under Copyright Act? So let's say I have made notes. Okay, I have made these notes. I have not registered with the copyright registrar of copyrights. Am I protected? Yes or no? I have made a song. Okay, I have not registered under the Copyrights Act. Am I protected? Yes or no? I have made a movie. I have not registered the movie under the Copyrights Act. Am I protected? Yes or no? I have done a performance. Not protected. So the answer is, it is not mandatory. It's very, very interesting that for copyright, moment the work is created, copyright protection is available. Registration is not mandatory. Instead, in the act itself, they use the word may. You may register. Then what are the benefits of may? I don't have to prove. I will, in case of dispute, then I have to sit and prove. It takes time. But when you are registered, relief will be given much faster. Okay, so that is the reason for getting registered, that in case if any dispute is there, you will get relief faster. Okay, so now we will see section number 44 to section 50A. Registration of copyright. Chapter 10, section 44 to section 50A of the Copyrights Act. It says that registration is optional. Section 44, that registration of copyright is not mandatory. You can still sue for infringement even if your work is not registered. Okay. Who can register and how? But when you sue, obviously you will have to prove that you had priority rights, you had prior publication, you will have to prove that you are the owner, so that can take some time. Who can register? Obviously the author, publication, any person who has interest in the copyright can apply for voluntary registration. The act itself is saying that you may register, so it signifies an option. Then artistic work and trademarks, if they realize that anything is touching upon some other trademarks, etc., then the certificate or NOC from trademark registry is required. Not that important, but just if we feel that, listen, you're touching upon someone else's trademark or a trade work or something like that, we will say give a NOC from this registry. The registrar of copyright may hold an inquiry and then record the details of the register of copyrights. So once after conducting inquiry and they find that you are the owner, they will register it in your name, and there will be the registrar of copyrights will have a register of copyrights where the owner's name and his copyright work will be mentioned. Now, registrar of copyrights possess certain powers of the civil code. Now see, registrar of copyrights, he has a right for registration. If someone is raising objection to hear the registration, he can summon any witnesses, he can do inquiry, he can examine on oath, he can do evidence. So he will have all the rights which are given under the Civil Procedure Code 1908. That is summoning any force, summoning, that is calling any person or attendance of any person. Discovery of any document, he can say that first he'll say call the person, then he'll say call the document. He will tell come with affidavits. He will count the witness. He will examine the witnesses, cross-examine the witnesses. Requisition of any public record. He can request any public record from any court. He will say that if there is an order of the court, please produce it. Any other matter. Very, very simple. In Sanjay Soya versus Narayani Trading Company, in this case, the same thing what I have taught you has been repeated. That registration is optional. In section 45 itself, the word may has been written, which signifies that it's an option and still protection can be given. Because copyright law intends that moment the work is created, you get automatic copyright protection on creation of the work. The Bombay High Court stated that the copyright registration is not mandatory for seeking relief. Court cannot reject you relief if you have not registered. The Berne Convention and the TRIPS Agreement also support the same thing, and section 45 and 51 state signify by using the word may that it is optional registration. But listen, I am asking you, if you are a advisor, would you recommend it to be registered or not registered? Will you ask that the copyright work should be registered or not registered? Obviously, you will tell that get yourself registered. So the Copyright Office has been made to take up applications. Online applications are also there. The rules have been given in 2013. The steps are very simple. You will give a form. If you have three copyright works, individual application for each work, along with your application fee, all the supporting documents, power of attorney, if someone else is going, agent is going, lawyer is going to sign it, the copyright fees has to be paid. It has to be in the specific form. Once you do that, so once the application is given, okay, the application is given, the controller or the registrar of copyright will publish it and seek objection. So there will be a publication that this person is the owner and he will invite objections. After inviting objections, he will hear both the parties. Okay, both parties will be heard and then the order will be given. Order could be there for allowing the application, for rejecting the application, or to modify the application. This we are talking of copyright registration. Okay, you have to make an application to Copyright Office. Simple. So application along with the DD fee has to be given. Okay, 30 days you have to wait for people to object. Once you give the application, then you will wait for 30 days for objection and then you will pass the final order and then put it in the register of copyrights. Now, once the registration is done, you are the entitled owner. Then comes a very important thing is of infringement. Infringement means what? Infringement means unauthorized use of the copyright work is called as infringement. A copyright owner gets exclusive rights to derive the financial benefits, okay, from his copyright work. If any person is without the proper authorization, is doing any of the acts, we will see which acts, either making copies, either making modifications, either making available to public, or doing anything against what the author has permitted, will constitute infringement. Now section 51A says that when a copyright is deemed to be infringed, so this is called as deemed infringement. Deemed infringement. See, what do you mean by deemed infringement? If they ask you, so section 51A states when it is deemed to be infringed. So you think and tell me, I won't tell. Deemed infringed. How you will say that it is infringed? If someone is doing anything which is an exclusive right of the owner, it is infringement. Exclusive right authorization. See, infringement occurs when someone performs an action which is exclusively reserved for the owner. For example, selling, modifying is the owner's right and you have done, it is deemed infringement. Second, a person is putting this out to public and earning money. He is earning profit. So from your work. So again, that is also deemed infringement. Communication for profit. Allowing a place to be used for publicly communicating the copyrighted work. For example, we saw all these IPL matches are there. IPL match, what I do, I put it in my colony and I start selling off tickets and I start telling people that you all can come on commercial level. This will be deemed Because what are you doing? You're using a public place to communicate a work, copyrighted work. So it is deemed infringement. Now the common types of infringement action, section 51B. What are the most common things that happen? You can sell or hire the copyright work. So this is infringement. So this is who is doing any other person other than the owner, unauthorized person is doing any of this. He is distributing for the purpose of trade, which is prejudicial to the owner, distribution of the copies, pirated copies, public exhibition of your work, okay, of the copyrighted work, importing into India any infringement work is again infringement. So if for example there is some CDs which have been illegally made, I have imported it, that is also, whether used in India or imported into India, is all considered to be infringement. What do you mean by infringing copies? So you bring anything of the infringing copies. So infringing copies mean what? Think where all copyright exists. So copyright exists in literary dramatic work, it exists in cinematographic work, it exists in sound recordings, it exists in computer program. So infringing means what? With respect to literary work, reproduction of the literary work. With respect to cinematography, a copy of the film. Basically just means copying any of this. So if you copy any of this or put it out for commercial renting, etc., is meaning the infringing copy, that copy. So a copy of the film is an infringing copy. A copy of the computer program is an infringing copy. A copy of the sound recording, which is got without permission. For example, let's say there is a very famous software for accounting software, which is Tally. In the market, when you go or when you see Microsoft Word, okay, when you see Microsoft Word, etc., you get a lot of pirated versions, pirated copies. So these are all called as infringing copies, because a copy of the literary work, cinematographic, sound recording or computer program are all called as infringing copy if it is a person other than the owner. So these are the common ways of infringing: sell, hire, displaying, distributing for copies, public exhibition or importation. We saw all of this. Now in S.K. Dutt versus the Law Book Company, that it was held that infringement of a copy, the onus of proof is on the plaintiff to satisfy that the defendant has infringed the copyright work. Again, there is a person who must have filed a case, plaintiff, and there must be a defendant. Plaintiff is alleging, is a complainant, and defendant has to defend. Now, onus, burden of proof is on whom? Whether the plaintiff has to prove or the defendant has to prove that he has not done anything wrong. You tell me, do the plaintiff have to show that the copies have been or the copyright work has been copied, or the defendant has to show that he has not copied? If I tell you are a thief, I will have to prove, or you have to prove that you are not a thief? Obviously, burden of proof is on the plaintiff. So the plaintiff will have to prove that the defendant has made a infringement of copyright work. Clear? Now, whenever we have these infringement actions, we will immediately have lawyers from both the sides. One will try to defend it, defend the accused, or defend the person who has been alleged to have violated. So this is very, very important, very, very important. These are all nothing but defenses. If I show that any of this has been done, okay, is in my work, or the person who has done the infringement, who is alleged to done, if he's done any of this, it will be treated that he has not done anything wrong and no case will be there on him. These are exceptions to the infringement. If imagine if someone is for private study, for private purpose, for research work purpose, for education purpose, for government purpose, all of this is allowed. This is not infringement. So these are all instances of not infringement. Now I will tell you from examination which is important. Okay, some of the points you can read through, but I will tell you which is important. I will discuss most of them. Okay, and I will mark and tell you which comes in the exam. Okay, first I will read through all. Statutory exceptions to copyright infringement under section 15. First one is fair dealing for personal use, criticism or reporting. Activities like personal use, research, criticism, reporting current events, including public lectures, do not constitute infringement. For example, anything in which I am acting bona fide, I am fairly using it for my own use. For example, I am listening to a song. It is not infringement. Second, I am playing a song and I'm saying what a shameful song they are using, what dirty lyrics. So it is public criticism. Or someone is reporting that an event is happening of XYZ person. So all this is not infringement. Second, now when we talk of computer programs, okay, someone taking a backup, a temporary backup is allowed. It is not a infringement. Interoperability of information extraction. Now what happens is actions needed to extract essential information for the interoperability or interdependent of computer programs are allowed. For example, if I want to use a software into my computer, so I tried interoperability means what? A communication between two computers or two devices or two softwares. So to make it compatible, work together, I can extract some information. It will not be counted as infringement. Observation and testing of computer. So if I'm doing for testing purpose, okay, for studying a computer program, it is not there. So sometimes we see, in all these colleges, they do the, extraction, and they try to dissect it or try to understand it and for more purpose. So it is not a infringement. Non-commercial personal use for copyright program. So for example, I am using Zoom software. Now it is for personal use, right? So it is not, I'm not selling the software, I'm just using as per the terms. So non-commercial use, if again I'm listening to a song, it is a non-commercial use. More of these points are overlap only. I will tell you which is the most important. Transient means temporary storage during transmission. So when I am taking some software, I want to transmit it into another computer. So temporarily I store it in my hard disk and then I will put it there, reinstall it there. It is not a infringement. Incidental storage for access, okay, or integration. Again, transient temporary storage or providing electronic links. If a written complaint is there, the facilitator must refrain from accessing for 21 days or until a court has given the order. So again, incidental storage for access. So if I want to provide access, I store some information, again it is not a violation of a copyright. Okay. Judicial work for courts, to produce it in courts, it is not a copyright work. For legislative work, while making the law, they would require, again they are exempted, they can use it because they are making the law. Certified legal copies, if someone is making a certified legal copy of the literary work, it is not a copyright infringement. Public reading or citation. So again, if I read it out, a book, a particular novel in book, it is not a for public displays or something like that, it is not a violation. Educational collections, okay, for instructional purposes allowed. Education. So most of the time education will be exempted only. Backups has been repeated multiple points that for taking backups also it is allowed. Fair use, personal use also has been mentioned multiple times. Now this is important from exam point of view. Important. Okay, so whichever is important and can come for the exam, I'm marking it as important. So educational use exemption under section 52(1) subclause 1. Section 52(1) permits the reproduction of any work by a teacher or his pupil during the course of instruction, as well as a part of any question to be answered in the examination, without constituting infringement of copyright. Very simple. If so, I am teaching you, right? I am your mentor. If I am using some text to teach you, okay, and I'm not saying that that work is mine, I'm just reading out something so I can educate you, so that is not a copyright infringement. Second, from any textbook, from any medical book, any law book, I have put out a question and framed it as and in the model answers I have taken that paragraph. For example, your ICSI modules, they must have taken some reference from some other books, commentaries, etc. So that is not a violation. Next, educational performances. Performances of work in educational settings are exempt if the audience is limited to staff, students and their families. Again, a small audience, it doesn't look like a commercial audience, so therefore it is exempted. Non-commercial public playback. Now again, I go in a garden and I play the songs and everyone's dancing on 31st night. It is not a particular infringement because it is non-profit. Performance by amateur clubs for non-paying audience. So amateur club means what? They must be having these fight clubs, these kind of Lions club, and it is an NGO. An audience who is coming is a non-performing. So more or less the same point, that public song is being played and it is a non-paying audience. So it is allowed. In your college, when you go, you might listen to so many music during your college events, right? Newspaper articles on current topics. Okay, all of that, whenever it is mentioned, religious issues are allowed and not an infringement. Reservation in non-commercial libraries. So non-commercial public libraries can store the books, okay, provided they already own a non-digital copy. So if they have bought, they can put it as a book. So for example, I can buy books and I can read it, keep it as a public library that you all can come and read here. Now this another thing is very important, very important from exam point of view. This they have asked multiple times in your exam. Limited copies by non-commercial libraries. Now pay attention to every line. This is what comes in your exam. They will frame a situational question or something like that. Let's see. Up to 3 copies of a book, 3 copies may be made for a non-commercial library if such book is not available for sale in India. So how many copies can be made? Up to 3 copies of a book can be made in a non-commercial library if the book is not available for sale in India. Simple. So they asked that a book was not available and a librarian made 3 copies of it. Allowed or not allowed? Answer is allowed. Why? Book was not available in India to buy. So example, a non-commercial library in India finds that a specific academic book required for research is not available for sale in India. Under this clause, the library is permitted to create up to 3 copies of this unavailable book for its collection, or up to 3 copies. Reproduction of unpublished work for research. So for research purpose, it can be taken up. Reproduction of official documents. So now again, official documents like acts, etc. So for example, this is made from the Copyrights Act. So it is not an infringement because it is used from the, it's a reproduction of the legislative acts. Translation of legislative acts. So again, one is reproduction of the acts by themselves, or the other one is translation by explaining, simplifying. Artistic work in architecture, making or publishing paintings, drawings, engraving or photographs of architectural work is permitted. For example, someone takes photos of the Taj Mahal or of the Burj Khalifa is not a violation. Public artistic work, making or publishing artistic works that are permanently located in public spaces. So again, there must be a statue. I have made a particular drawing of those statue. It is allowed. Taj Mahal is there in Mumbai. I take it, or the Red Fort is there, or in Coimbatore they have a very good sculpture. If I draw it, it is not a violation. Artistic work in cinematographic films, including artistic work films as backgrounds or incidental content, is allowed. Used by original artists for mold. So basically, when they're saying artistic work in cinematographic, including artistic works as backgrounds or incidental content, for example, spoofs is an incidental to a cinematographic work which is there. Spoofs are made of movies, so that all is allowed. The author of an artistic work can use molds, casts, sketches, plans made by them for the purpose of the work. Original artist can use his work. It is not a violation. Now, three-dimensional objects from two-dimensional object. Creation of three-dimensional objects made on two-dimensional work for industrial application is permitted. Creation of three-dimensional based on two-dimensional work is allowed. So there must be a drawing. I must have made a 3D object. So it is not a violation of it. Now all of this is subject that I am not selling and making more profit out of it. It is for some industrial application, etc. Reconstruction of a building. Again, drawing up a building is allowed. Especially, let's say the original plan. Let's say there is a redevelopment of a building. I use the original layout plan to reconstruct the building is permitted. Exhibition of work in expired copyright films. So once the work is expired, you can definitely use it, not a problem. Imperial recordings by broadcasting organization. Making and retaining imperial recordings for broadcasting is permitted under the specific. Imperial recording means short term, short-lived recordings by broadcasting organizations. We saw broadcasting organizers have a right to broadcast, rebroadcast as well as record. So they can do. Okay, performance during religious things. So again, during religious and official ceremonies we play. During the Sangeet, certain songs are played. It is allowed. Accessibility of persons with disabilities. Now what happens, there must be a book, just we have made it in a way that in braille, for where person who have vision impairments or who are blind can read those books, is not a violation. Now we were done with all the defenses to infringement or the exceptions stating what are not infringements. Now there is a very classic case, or University of Oxford. Imagine Oxford University filed a case in India against whom, do you know? It was a very classic case of Rameshwari Photo Services. So the University of Oxford filed a case on a Xerox copy person, Rameshwari Photo Services. What happened is, University of Oxford, they had various books. They realized that Rameshwari was photocopying the books and students were taking photocopies and studying, and they were not buying original books. As law students, sometimes they take Jabwala, they take a Xerox, they take Mokal, they take a Xerox. You must be doing Xerox of the scanners. So the original publisher filed a case on the Xerox guy. What do you think? Who will win? Is it allowed or not allowed? So the answer is, it seems a little wrong, but the government of India sided with, helped the Rameshwari Photo Services somewhere. Okay, University of Oxford filing it on an Indian, so we will have a soft corner towards Indian. It was held that Rameshwari Photo Services were not wrong. They can make photocopies. Why? Because it was for educational bona fide purpose. Okay, so though it can be debated, but the courts have favored Rameshwari Photo Services, and they said that University of Oxford will not get relief, not get any injunction. So University of Oxford filed a lawsuit seeking a permanent injunction against Rameshwari Photo Services. The plaintiffs accused the defendant of infringing the copyright by photocopying and distributing on large volumes. The courts interpreted that, listen, your copyright work is not absolute and divine rights. Okay, it is main logic is to enrich public knowledge and stimulate creativity and innovation. There is a line in section 52(1)(I) which states that in the course of instruction between student pupil, that is for educational purpose and for academic reasons, it is a exception. So here the court findings held that the defendant's action of making and distributing photocopies for academic purpose does not constitute a infringement on the plaintiff's copyrights, and a permanent injunction was denied. So again, Ramesh, so a very famous classic case it was, and you can quote it in your exam. University of Oxford versus Rameshwari Photo Services. It is with respect to section 52, defenses under infringement of copyright. Then came remedies for infringement. The owner, what remedies will the owner have? So we will see, he will have damages, he can ask that it should not, injunction he can get, we will see. But before that, we will try to understand who is the owner. So owner is first the exclusive licensee. The owner includes, see, owner obviously is the author, original author. It also includes the exclusive licensee, any person who is holding a license or an assignment in his name, and also the publisher in case of anonymous work, okay, until the actual identity of the author is revealed. So a publisher, for example, a publisher published a book, we don't know who the author was, so anonymous. So till then the publisher will have the rights or will be treated as the owner. Remedies are being given, civil remedies, very very important, section 55. What remedies are there on infringement of copyright? First, what all will you ask? You will ask for injunction, asking the person to stop using the infringing copy. Second, you will ask for damages, monetary compensation. You will ask that how much ever profit he has made, that profit to be returned, that is called as accounts or accounts of profit. You will ask that all the infringing copies should be delivered to you or destroyed, and any other remedy which the court feels fit. So this is all given in section 55. Okay, the court can order under section 58 for the infringing copy and production. See, the copyright owner, legal procedures for confiscation. The copyright owner also has a right to two things, that is given in section 58. He can tell that all the infringing copies, whichever the infringing copies, give it to me, one. And second, whatever other production plates, the digital files, etc., they also should be returned to me. Now all plates means what? Imagine for printing they have these special plates, or any digital copies, that all also has to be returned. So the copyright owner can initiate a legal proceedings to claim possession of all the infringing copies and any kind of production plates, if any. Civil remedies we saw. Criminal remedies are very simple again: imprisonment, fine and seizure. Now border enforcement. Now when I say border enforcement means what? We are talking of some international protection. So prohibition of import. You have a right that if you have any infringing copies or any copy or any duplicate copy or any pirated version is being imported, you can restrict it and ask it to be destroyed. Penalties and protection of rights of management information. Now very very interesting, let me explain what is ERMI. RMI means rights of management information. For example, like for our app, you can download our app Jahangir Tutorials. Okay. In the app, you will see that we have a lot of you know prevention and control of our work, of the work that we have created, of our lectures, of our notes. A lot of protection has been done and the industry best standards have been used. Where what happens is any data, if someone related to any attached files, to control their use, distribution, access in order to protect the intellectual property. So first, the management rights, what do we do to use, distribute, access? We have certain rights and powers which we use. For example, we can tell that our lectures can be seen on how many devices? On 2 devices. We have allowed on multiple devices you can watch our particular lecture. So this is a management right, we can decide. But if you log in into one, you will be logged out of the other. So at one time you can watch it in one device only. You cannot copy the text from the ebook. So if an ebook is there, you will not be able to copy. It will show that it is copyright restriction. You cannot share the ebook. Nowadays, what used to happen in Netflix, multiple users were watching the same thing at the same time. So these are all management rights. Validity. So our lectures validity, or they can keep it for 1 year. Till that, unlimited viewing is allowed. In some of the PDFs online, you can see that printing is disabled. We can also do that in our particular app. So what are these? What are these and why are we doing this? So the electronic rights management information to data attached to the digital file. So whichever digital file, ebooks we have, is the rights attached to our digital files. Now penalty is there. If, for example, there is a hacker, ethical hacker, he goes in and makes a change in our particular software where the video can be watched for more than 2 times, or it has become publicly, he's unlocked all the lectures. Okay, so anyone who removes or alters any rights which the management has without our authority, okay, or makes copy of our works, okay, they start downloading and then uploading on their channel. Okay, and so shall be punishable with imprisonment up to 2 years and shall also be liable for fine. It may be noted that rights management information means the title, identifying the works. So our lecture title, the name of the author, the name of address of the author, the terms and conditions, whatever it is there. So what all terms you will get, so even Netflix, it gives you all the terms and conditions and what all restrictions are there on the particular digital file. Now offenses and penalties, again, section 63 to 70 deals with offenses and penalties. Offenses of infringement of copyrights and associated rights. So if anyone does this, a penalty is there, 6 months imprisonment, which will be extendable up to 3 years. Now tell me one thing, did you see that, does it look like a small offense or a big offense? Look at this line, okay? Penalty is minimum 6 years imprisonment, means the person will definitely go in jail. So obviously it's a very serious offense. Okay, and fine, a minimum fine of 50,000, which may extend to 2 lakhs. Now in Jitendra Prasad versus State of Assam, punishable with a term for which may extend to 3 years are non-bailable. Okay, in this court they have said that. So again, let me just put it to you. Violations of the intellectual property rights or copyright violations is a non-bailable offense. You can please take a note and write it down in your books that these are all non-bailable. That doesn't mean you cannot get a bail. You will not get a bail as a matter of right. In bailable offense, you just make an application and bail will be granted. In non-bailable offense, you will may or may not get a bail. You will have to prove to it's at the discretion of the court. The judge may or may not give. Normally they will not give, but in extreme cases they can give you bail also. So normally in non-bailable offences you can file for anticipatory bail. This is what they are saying. Because in anticipatory bail, if you are anticipating arrest, because you know that it is a serious offence and you will be arrested. So moment the FIR is lodged, moment the FIR is made, and you know that now police will come anytime to pick me up, I'll call my lawyer and say get a NBA. ABA. ABA is anticipatory bail application immediately filed. And because only in non-bailable offences you can file anticipatory bail application. And second, these are serious offences, okay? So these are all called as cognizable offences. See, the word cognizable means serious. So offences under the act are cognizable and non-bailable. Please note it down. It has been stated under these sections as well as in the case law. Now there was another case law, NIT Pro versus State of NCT of Delhi. Again, same points have been held, that Supreme Court clarified that section 63 that we saw, okay, what we are seeing here, section 63, and which I have told you, this is the under section 63. What the Supreme Court said, that when they are saying that you are going to be punished not less than 6 months but 3 years, means that all these offences are considered cognizable, serious. Hence, offences punishable with less than 3 years are non-cognizable. Okay, under the IPC, if it is punishable for 3 years or more, but not less than 7 years, we'll see. Now, what are they saying? That what falls under cognizable and not? The High Court had made an error. Supreme Court found that the High Court had made a grave error, classifying that section 63 as non-cognizable. Cognizable means serious. Non-serious offences, High Court by mistake classified it. So the High Court's decision was squashed and set aside the High Court decision. Okay, and stated that this is the main thing, that offences under section 63 are cognizable and non-bailable. This is the essence of the case law. Market is important. What is the essence of the case law in NIT Pro versus State of NCT Delhi? Power of police to seize infringing copies. Again, police officer has if it is a cognizable offence. Now, what do you mean by the term cognizable offence? I told you, cognizable offence is a serious offence. In serious offence, a police officer can arrest without a warrant, can arrest without a permission of court, which is called as arrest warrant. So without any arrest warrant only they can arrest. For example, if there is a terrorist, the officer will not go to ask in court whether I can arrest you or no. It's a serious offence. He will directly arrest. So here this is what they are saying, that a police officer can seize infringing copies without a warrant. He will place it before the magistrate. Section 65, possession of the infringing plates. Now plates are, to print you require certain printing plates where the same copy can be made. So illegal possession. Illegal possession of any of the infringing copies is prohibited, and you can get a jail up to 2 years and fine. And that is it. We've completed the entire chapter and no question can come outside than what we have done. Clear. So I have completed the entire chapter. I need you all from the particular chat box to tell me whether you've understood or not. So I have completed the entire chapter yesterday. The last part 1 and part 2, if you do, your entire chapter will be done in depth. Clear? So that is it. I am done. I need a confirmation if I'm audible and visible. I need a confirmation if you've understood everything clearly, so we can end today's lecture. Have you understood everything properly? Okay, great. So that is it for today. Thank you so much. I will see you all tomorrow with another new chapter. Take care, guys. Bye.